Okay, please proceed.
Thank you. Good morning, Your Honors. May it please the Court, my name is Emil Saman, and I represent the people of the state of Michigan as the appellate in this case. I would like to respectfully reserve 2 minutes for rebuttal, and I will waive the 2-minute free fire zone this time. Your Honor, in this case, the defendant was convicted of 2 counts of unlawful imprisonment and a felony firearm third offense. The trial court sentenced the defendant to 10 years for the felony firearm. However, the Court of Appeals reversed based on this court's holding in People v. Stewart. The MOA was granted here to decide, 1, whether the plain language of the felony firearm statute requires 2 prior convictions to have arisen from separate incidents, and if not, whether People v. Stewart should be overruled. The people submit that there is no separate incident requirement for the felony firearm third statute, and therefore People v. Stewart should be overruled.
What happens if a defendant is convicted of 3 counts of felony firearm with 3 separate predicate felony offenses arising out of the same incident? Could the court sentence the defendant to 2 years on the first one and 5 years on the second one and 10 years on the third one?
I would submit, no, Your Honor, that is not a prior conviction. It would be a simultaneous conviction. You would actually not have, under the language, the prior conviction situation here. And I believe People v. Sawyer actually addressed that specific question, and there's no reason to change that at this point. It would be different had a subsequent or later conviction come about. But when you have simultaneous convictions, I don't believe you would have that issue.
But this statute speaks of a second conviction or a third. It does say third or subsequent, but it doesn't. The subsequent there seems to me to mean 4th or 5th or 6th, not subsequent time-wise.
Perhaps, but when you're dealing with a simultaneous conviction, you technically don't have a first or second. You have 2 at the same time. So in that situation, I don't believe you actually really count the second. Now, when you get to later stuff, if you had the first one, and then later on a defendant commits 2 felony firearms in the same incident, that would also only be a 5-year conviction because you only have 1 prior. Not simultaneous convictions get counted as 1 and 2 until a later conviction happens.
Does your office have any policy with respect to whether they would charge multiple counts of felony firearm arising out of the same incident? Or is it more common to charge 1 count with multiple predicate offenses?
It would depend upon the facts of the case as well as the probable cause of what is allowed. For example, if we had a situation where you could have a felony murder or a murder first degree with a gun, and then a second person is assaulted but not killed, and that's, for example, an assault with intent to murder, you would have 2 separate felony firearm charges. If you have a situation in which you have perhaps an open murder, the felony firearm would attach to whichever one it would come out. It would all depend upon the facts of the case and the charging discretion of the prosecutor who is charging that. But even looking at this situation, the plain language of the statute is unambiguous, meaning that there is no separate incident requirement entailed in the statute itself. Stewart added that requirement. And if we want to look at situations where there are separate incident requirements, one does not have to look farther than the drunk driving statute as well as the 2012 amendment to the habitual offender statute. Specifically in MCL 257.625, subsection 27, it states if 2 or more convictions described in subsection 25 are convictions for violation arising out of the same transaction, only 1 conviction shall be used to determine whether the person has a prior conviction. In the amendment, 2012 amendment to the habitual offender statute, subsection 1A, where it adds a mandatory minimum of 25 years for a serious offense, it states, not more than 1 conviction arising out of the same transaction shall be considered a prior felony conviction for the purposes of this subsection only. Thus, the language of these statutes shows that the legislator knows how to add the specific language it requires to have a separate incident test. The felony firearm statute has no such language, and when Stewart added it, it was incorrect.
So we don't ordinarily overrule our cases just because they're wrong. So even if we concede that, if we agree with you that they're wrong, what should we do with it? I mean, it's a holding of this court, so.
Well, the court can basically overrule People v. Stewart, and I believe Justice Markman said it in Naraki. A judicial tribunal is most strongly justified in reversal of its precedent when adherence to such precedent would perpetuate a plainly incorrect interpretation of the language of a constitutional provision or statute. Stewart was incorrectly interpreted and has
So-
become precedent to this point.
Okay, but we have this multi-factor test in a case called Robinson about when we overrule our precedents. So maybe you could help us with that a little bit?
Sure, the stare decisis, and specifically the three-step analysis, whether the decision at issue defies practical workability, whether reliance interests would work an undue hardship, and whether changes in the law or facts no longer justify the questioned decision. I believe People v. Gardner laid out exactly those factors when they overruled Preuss and Studemeyer. And in that situation, they discussed there is no reliance interests, because for reliance interests, the question for reliance is, will it be thwarted by overruling the case, will cause significant dislocations or frustrate citizens' attempts to conform their conduct to the law? And in Gardner, they say no, because simply put, by committing the crime, they're already outside societal norms in that situation.
Yeah, so that piece of Gardner is a little troubling to me. Because it seems to me that the intuition behind, I'm not saying there's an ex post facto clause problem with a court overruling its prior precedent, because the ex post facto clause only applies to the legislature. However, the basic intuition behind the ex post facto clause is that people do rely on the sentences attached to criminal conduct, and that they can't be changed after the fact. And so the basic intuition behind the ex post facto clause suggests that there would be a reliance interest sufficient that it's constitutionally grounded when it's done by the legislature. And so I'm wondering about that piece of Gardner and how we should think about it, because it's a court rather than a legislature.
Well, I think the reliance interest would have to be that citizens, as well as attorneys, should rely on the courts to interpret the plain language of the statute itself, which is also what Gardner said. And the idea is when you read the statute and no language indicates a separate incident requirement, by simply adding that language prior, does not make it accurate. So going forward, and especially with this case, I don't think you would have the ex post facto issue, because by the plain language of the statute itself, there is no separate incident requirement. Would we go back now and start resentencing all the old people for felony firearm third? I don't think that's going to happen in this situation. Whether that's retroactive is a completely different issue. But prospectively speaking, when reading the statute, showing that there's no separate incident requirement, a third or subsequent felony means you will get 10 years. That is the plain language of the statute. It's unambiguous. It's not really questioned.
And so that intuition, I mean, if we're going to go there, maybe this is right, maybe this is why the ex post facto clause only applies to legislative judgments and doesn't of its own force apply to judicial overrulings, although there is U.S. Supreme Court doctrine that says that similar due process concerns attach to judicial overrulings of cases like this. But, you know, we could talk about whether they apply. Your argument would have to be that citizens can justifiably rely only on the text of the statute and don't need to concern themselves with judicial interpretations thereof?
Well, no, I would respectfully disagree. I would say
so if that's not it, yeah, help me, because I'm
I would say
struggling with this a
that
little
citizens should rely on the fact that judicial interpretations will be to the plain language of the statute itself.
So they can rely on the judicial interpretations when they're correct and not when they're incorrect.
Or unnecessary. So the judiciary didn't need to construe the statute because the statute was clear on its face.
Correct. So when Stewart added a separate incident requirement, it expanded the statute beyond what the language said.
I just think that people are going to have a hard time with a rule that says, well, I read the statute and I think this is what it means, but then these 7 people who sit on our Supreme Court said it meant something different, but I shouldn't rely on what they said. I should rely on my as a citizen, read of the statute.
Well, I think the very first reading of the statute is don't use a gun and commit a crime. And once you get past that point, every time you do that, there's going to be a penalty for that situation. And that's really the harm that is being addressed with the statute.
Yeah, so that would make a lot of sense if the ex post facto clause itself didn't attach to retroactive changes in the penalty. That would be great. Then I'd have a clear understanding. I'd say, look, law-abiding citizens rely on the law. Once they decide to take themselves out of conformity with the law, they're not law-abiding, and I can't expect that they will rely on the law. They didn't rely on the law in the first place. But it's very clear that the ex post facto clause itself and the due process clause, to some extent, does attach to changes in the penalty. So
Well, that would be-
I'm just struggling a little bit with the reliance piece of
Well,
your case.
if the ex post facto would apply, it would only if the legislator had changed the law. Here, when I'm asking, I'm not saying the legislator should change the law or
I'm
needs
not
to.
saying it's an ex post facto clause violation. It is not, because the legislature didn't change the law. I'm just struggling to figure out how judicial changes in the law play into that basic intuition behind the due process, or due
Well,
process and ex post facto.
For due process, I believe the issue we're talking about is the procedural one where notice is given and how they can deal with that notice, not substantive due process. Would that be correct?
Yes.
Yes. And for the notice, I believe the statute puts you directly on notice of what the penalty is. And the penalty is 2 years, a second, 5 years, a third, or subsequent 10 years. If you have 3 felony firearms, you are on notice that 10 years is a good possibility. And the fact that the court may have made a mistake in Stewart does not mean that they don't have this court does not have a duty to correct that mistake and make the proper ruling of law.
So, do my colleagues have questions? I don't want to.
Oh, go for it. You're doing great.
So let's say that I remain troubled by that prong, the reliance interest prong. Is there a case that you can make that even though I might be troubled about the reliance interest prong, our other Robinson factors suggest that the case should be overruled anyway?
Well, I believe the practical workability factors also weigh in favor of that because it is easier, it's more simple to count each felony as probably more workable than the judicially imposed same incident rule. Counting 1, 2, 3 is much simpler than trying to figure out which date, if they happen from the same incident, if they happen from the same separate incident, and make that. So practical workability-wise, that's a much simpler factor. As for changes in the law or facts that no longer justify the question decision, there really was no change in the statute because the amendments that happened to the statute had nothing to do with this prior conviction language. But if you look at the facts of other cases, specifically the OWI statute or the law of the OWI statute, the law of the amendment, the 2012 amendment to the habitual fourth statute, it shows that the legislator knows how to add a separate incident requirement, which I think would go more in step that Stewart wrongly decided or wrongly interpreted the felony firearm statute. As such, those 2 factors alone, I think, would outweigh the reliance factors because I still believe that the reliance factors would not be harmed here by overruling Stewart.
Isn't the reliance interest something that's not simply focused upon the extent of a person's reliance upon the language of a statute to understand that statute, but also his reliance upon the statute in conforming his conduct to that statute? In other words, in applying it to the statute we have here, there'd be at least the question asked whether or not, given one's understanding of past judicial interpretations of a statute, one might have gone about carrying a firearm in the course of a felony in the thinking that if apprehended, the punishment would be something different than the eventual punishment was in fact. Isn't that a separate concept of reliance?
Well, yeah, I think under the reliance analysis, you look at that whether or not overruling the case will cause significant dislocations and frustrate citizens' attempts to conform their conduct to the law, which is why I stated originally, when you're pulling the gun, you're committing a crime, a felony, and then having that attached to the felony, you're already not conforming to the law.
I mean, a person who's purchased insurance, a person who's not purchased insurance because he believes that his circumstances are not those that, need to be subject to insurance, such a person might in fact have a reliance interest when it later turns out that persons in his situation indeed do have some obligations of insurance.
Yes.
That's a false reliance. That it seems to me is in part the reliance interest that's focused upon Robinson, is it not?
Yes. But I would say here you have the situation where when they commit the felony firearm, the nature of the criminal act here defies any argument that the offenders are attempting to conform their crimes to societal norms. And the situation here is I don't think they would want to rely on the fact that, well, if I just commit this armed robbery and this armed robbery at the same time and use the gun on both victims, I should only get 2 years. And then later on, when I do it again, I only get 5 years, not 10 years. And that is We don't reward, the statute itself does not reward for being economical in who you choose as a victim or when you choose as a victim, nor does the statute or the legislator intend to give that type of benefit for the harm they're trying to combat.
And wasn't it the point, too, that it's the increasing clarity of the statute that's a factor? In other words, to the extent that the statute is increasingly clear that it's focusing upon up and down as opposed to something else, isn't that the point of it? I mean, the more ambiguous, the less clear, the less self-evident the statute, the more that people have the right to rely upon the legislative determination as opposed to the judicial determination.
Yes, and I think here you have a completely unambiguous and very clear statute, specifically that no separate incident requirement exists.
I mean, the conundrum that's been identified is certainly a relevant conundrum, but it's not caused upon the person who's relying upon the law. It's a conundrum that's caused upon the court that's departed from the manifest or self-evident meaning of the statute, seems to me.
And I would agree. And I think this leads directly into the part of the respondent, or I'm sorry, the appellee's argument that this has been the law of the land for 24 years. And since it's been the law of the land, it should remain precedent. However, that's hardly dispositive. Stoudemire was in 1987. Proust was decided in 1990. Gardner, which overruled them both, was in 2008. That's 21 years and 18 years respectively before the court corrected what it considered a mistake in Proust and Stoudemire. The fact that 24 years has passed here is hardly dispositive, nor are the other arguments they make that it's correct precedent because the felony firearm and the habitual offender statute differ. They don't differ in one respect. They both don't have the separate incident requirement. It's unambiguous in that regard.
So you're saying there's a factor that wasn't announced in Robinson that might well be relevant in the context of considering whether or not to retain precedence, and that is whether or not there are other statutes that seem to be on all fours with the instant statute, and that they've been given an interpretation that's at odds with the interpretation given to the instant statute.
I think the two statutes I cited before, the drunk driving statute and the habitual offender 2012 amendment, show the legislator knows how to put that language into a statute, and the absence of that language does not mean it should be interpreted to have it or to import it into it. Therefore, we find that Stewart was improperly decided, and there is, this court should overrule Stewart and reinstate the 10-year sentence. Thank you.
Thank you.
Good morning. May it please the Court, Peter John Van Hoek on behalf of defendant appellee Dwayne Wilson. I think I've been representing Mr. Wilson for half of my career. I was here several years ago in the same previous part, but it continues. I normally would waive the 2-minute free fire zone, but I'm not going to do it here because I just want to make a couple of points first. Number one, this statute is not unambiguous, the felony firearm statute. The fact that the legislature used simpler, less complex language here than in the habitual offender statute doesn't lead to the presumption that, therefore, it's unambiguous. In fact, I would say the less the legislature says in the statute, the more likely, harder it is to interpret what they mean. So I don't believe this statute is unambiguous at all. I think it's very unclear what they intended in this particular issue. They're very clear when they say the first felony firearm conviction, you get 2 years, the second, you get 5, the third is subsequent, you get 10. That's absolutely clear. Nothing said one way or the other whether there's the same incident rule or not. So to say they didn't put it in there, therefore it's unambiguous that they don't intend it, ignores the fact that they didn't exclude it either. Okay. Second, the prosecution is alleging here because this court in People v. Gardner interpreted the habitual offender graduated sentencing scheme statutes in a certain way, that decision basically mandates this court to interpret the felony firearm statutes in that same way. And that is both legally and logically inconsistent with the basic rule we're talking about here, statutory construction. This court very clearly at Gardner and virtually every other statutory construction case says the first rule is the precise language of the legislation. And if that precise language is unambiguous, whether this court believes it's wise or not, this court's duty is to enforce that language, if unambiguous. And in Gardner, this court concluded the language of the habitual offender statutes are unambiguous and do not require the same incident rule. But you can't take that ruling and say it applies to different language.
So what do you think are the critical differences, the linguistic differences between the two statutes?
The difference is, in Gardner, this court relied upon the fact that the legislature amended the habitual offender statutes and put in this phrase, any combination of. That was the key to the Gardner decision, saying that the legislature changed the statute, put in a phrase, any combination of prior felonies, and interpreted that to be an unambiguous statement that in a subsequent case, looking backwards in time, any combination being subsequent felonies out of separate incidents or separate felonies within the same incident count. Okay. That language doesn't appear here. You can't premise your decision in this case on the phrase any combination of, because it doesn't appear.
But I mean, in Gardner, this court also cited these statutes from other jurisdictions that explicitly stated that offenses committed at the same time should be treated as one conviction.
Yes.
And because our statute didn't, isn't that same principle at work here? Don't we have that same issue with this statute?
Well, sure. I mean, I frankly, I disagree with Gardner saying that the habitual offender statutes were unambiguous because the habitual offender statutes don't explicitly say the same incident rule doesn't apply or does apply. They interpreted any combination of to be rejecting the same incident. And that's not explicit. This court said, we don't see how they could have made it more clear. Well, they could have made it more clear in one sentence that says the same incident rule doesn't apply. They could have done it here. But this statute is ambiguous because it doesn't say very much at all other than first you get 2, second you get 5, third you get 10. Now, Justice Viviano, your question is exactly my argument. If this statute is so unambiguous, then how can you say that in the same case, where you have 3 felony firearm convictions in the same case, you don't get 2 years on the first, 5 years on the second, 10 years on the third? It doesn't say prior. As you pointed out, the prosecutor said, well, you know, they have to be prior convictions. It doesn't say that. It just says 2, 5, 10. If this is unambiguous, how can you interpret it to mean anything other than?
The legislature could do that, though, if they wish.
They certainly can do whatever they want after today.
Well,
no one disputes that, but they haven't. Question is not what they could do, it's what they did do.
You know, I agree. I'm sort of pondering your point because I'm not sure it's pertinent to our discussion here. The question is, what did they do when they enacted the statute? And my question to you is, if it was their intent to allow prosecutors to charge and ask for a 2-year sentence and a 5-year sentence and a 10-year sentence, does anything preclude them from doing that?
I don't think there's anything in the law that would preclude them from amending the statute and specifically saying the first in time, the second in time, the third in time. If the time difference is only that the jury comes out at 10:01 and says you're guilty of felony firearm in count 1, come out at 10:02 and say you're guilty of felony firearm in count 2, and at 10:03 you're guilty of felony firearm in count 3, and the judge could say, okay, you get 2 years on count 1, 5 years on count 2, 10 years on count 3. The legislature could do that, but they haven't. What's interesting now, in Gardner, even though this court said the habitual offender statutes are unambiguous of not having the same incident rule, they then specifically rejected any claim that within the same case you can habitualize. They specifically said if you got one case, you're convicted of 2 felonies, you can't say the second one in time, the jury comes out with number 1, the jury comes out with number 2, you can't make number 2 a second habitual and get 1.5 more times. They understood the legislature didn't want that result. But I don't see how you can take the simple language in felony firearm and say it's unambiguous and at the same time say, but you can't do it in the same case. Because there's nothing in the statute that says you can't. And there's nothing in the statute that says you can. So how does it become unambiguous? Gardner is different. Let's talk about stare decisis, because that would seem to be the focus of a lot of the first argument. Gardner basically said, sure, stare decisis is important, but why they overturned Proust and Studemeyer relied a great deal on the fact that their majority opinion said in both Proust and Studemeyer, the majority ignored the fact that the habitual offender statute had been amended. And that amendment was critical because that was the amendment that for the first time put in the language any combination of. So essentially what Gardner was saying is not so much that we're overruling Proust and Stoudemire, but they were saying we're the first court to actually interpret the current language, because Proust and Stoudemire didn't. They ruled on the basis of prior, now obsolete language. So the considerations of stare decisis weren't really strong in that case, because essentially they were reviewing a new statute, not the statute that Proust and Stoudemire had or should have interpreted. Felony firearm statute has never changed since its enactment. There's no amendment here. There's no change. This court is essentially being asked to look back 8 years to People versus Stewart and say, Stewart Court, you were wrong. This is what we now think the statute means. I quoted the U.S. Supreme Court in Patterson versus McLean. The U.S. Supreme Court specifically said, considerations of stare decisis have special force in the area of statutory interpretation. For here, unlike in the context of constitutional interpretation, the legislative power is implicated and Congress remains free to alter what we have done.
Yeah, but this court has been kind of skeptical of that legislative acquiescence rule, wouldn't you agree?
I'm not saying legislative acquiescence. I think what they're talking about here...
Well, what's the difference between saying we should stick to our statutory interpretations with sort of some kind of super strong stare decisis,
Right.
because the legislature can change it, and saying the legislature, by not changing it, has acquiesced in our interpretation?
Well,
what's the difference?
I don't think it's really acquiescence. I think they're talking about the more basic concept of stare decisis, which is if you have a statute whose language doesn't change over a long period of time, and 10 years in, a court comes in and says this is what the statute means. And 10 years later, even though the language hasn't changed, a different configuration of the same court comes in and says, no, they're wrong. This is what we now think the statute means. And 10 years later, a different configuration of the court comes in and says, oh, well, the first court was right, the second court was wrong. We have a third one. To the citizens, the language is exactly the same. But the impact of that changes, not because the legislature has done anything, but because different setups of the court have reached different decisions. Now, you could decide, the six of you could decide this case today. A couple months from now, the new justice may not participate, but may come on this court. Somebody else may come in front of you and say, hey, those 6 people in Wilson were wrong, and now the majority switches, and it goes back to Stewart. I mean, that's what we're trying to avoid.
Counsel. So I understand, but all of what you're saying is just an argument about stare decisis in general. Stare decisis is good. It promotes stability. It makes the legislature believe that makes the citizens have confidence in the judiciary. But that would be true if this were a constitutional question, if this were a common law question, or a statutory question. I don't see how it differs because it's a statutory question. This court's doctrine on stare decisis seems to me is different than the U.S. Supreme Court's doctrine on stare decisis in that this court has rejected what I still think is the legislative acquiescence argument, an argument that our stare decisis needs to be super strong when we're interpreting a statute as compared to a constitutional provision or a common law provision. And I don't think you've offered an argument that suggests that that's not right. But if it's not right, or if we should rethink that, then I'm interested.
I understand that. I mean, I've read enough of the court cases to understand that the majority on this court for the past period of time has not given much credence to the legislative acquiescence argument. I'm just pointing out the U.S. Supreme Court basically thinks that the concept of stare decisis applies most strongly when you're dealing with legislative stuff, not constitutional stuff. But again, going back to Gardner was a case that didn't rely very much on, didn't care much about the stare decisis principles because they essentially said, we're interpreting a different statute than Proust and Stoudemire did. And that's not stare decisis. That's the legislature completely changes the statute. There's got to be a new interpretation. This is in this situation.
Can I invite you into my personal stare decisis swivel for a moment?
Sure.
So assume I think you've made some good points about the Gardner decision when it was made, and I see it maybe both about how it didn't really need to do the stare decisis work that might need to be done here because of the amendments in the statute, or at least that was one justification for why it might have been different. And also about, you know, maybe the statute could have been clearer if it added one more sentence. Maybe say I agree with all of that, but I, Justice McCormick, am committed to stare decisis, maybe even super statutory stare decisis if I'm allowed to be that. And I believe Gardner is our rule. And I think since Gardner is our rule, that somehow now undermines the confidence in the Stewart rule. So one answer to Justice Larson's question of your opposing counsel about reliance, which I think is an important and hard question in for your case, might have been, fair enough, Justice Larson, the reliance question is hard, but the Gardner rule has sufficiently undermined the rule of law in this case such that we should overrule this in this case as well.
Okay.
What's the answer to that? Now that you know my,
Well, the answer
I've
to
laid
that
everything on the table about how I'm in a swivel.
The simple answer to that is that the Gardner rule only applies in concerns to the specific language of the habitual offender statute and says nothing about the specific language of the felony firearm statute. I mean, if you're going to do statutory,
but those principles that I articulated before, you know, some of the things that we cited in Gardner are true here as well. You know, you could find statutes in other states where they were more clear about how to.
Unfortunately, we're interpreting our statute and not those. What I'm saying is that if we're talking about statutory construction, the principal rule being the precise language, you can't take a decision in a different case in a different statute or a different statutory scheme and say it's the rule for this statute and a different language in a different statutory scheme. I mean, the fact that they're dealing with similar concepts in the law graduated sentencing situations doesn't mean they're the same. If the legislature, if in fact Gardner is right and the legislature put in any combination of language to make it clear that they were rejecting the same incident rule, they could have put it in this. They could have put it in this from the beginning. They could have done a lot of things. Gardner was 8 years ago. It stays, and this has always been the law. We talk about reliance. Everyone, the initial sentencing in this case, the trial judge gave Mr. Wilson 5 years. And they were going to give him 5 years again until the prosecutor got up at sentencing after the retrial and the reconviction and said, oh, well, we think Stewart was implicitly overruled by Gardner. And the trial judge said, okay. Well, the trial judge was no big fan of Mr. Wilson. It doesn't surprise that they were trying to, given what happened in the case, given he got acquitted of the murder charge, they were very eager to give him a lot of time. I went to the Court of Appeals and said, you can't, the trial judge can't rule that a Supreme Court decision was implicitly overruled. And the Court of Appeals directly agreed. It's a different situation. The fact that they are in similar areas of the law, there are a lot of differences. If I could, well, I'm sorry. I mean, I tried to point out that felony firearm graduated punishment is much different than habitual offender, mandatory, consecutive, determinate. The legislature had to know the fiscal implications of that rule in terms of prison population and cost, of giving people 5, 10 years, mandatory sentences, no chance of parole, consecutive. If they would have thought that people can go from first serving a 2-year sentence, skip to 5 and go directly to 10, I presume they would have put it in there specifically, and they did not. That's why it's ambiguous.
Thank you, Mr. Van Hoek.
Thank you.
Case is submitted. Thank you.